Hi everybody, it's Mike Kennedy, Vermont Bar Council. Welcome back to the garage for another in the series of garage bar studio production CLEs I've been doing during the pandemic. It's Sunday, April 26th. I hope everybody's hanging in there, staying safe, staying healthy, being good to each other, being good to yourselves. Had a great run today. It's a little bit late right now. It's 7:30 at night as I record this. Had a good run, really good run. Got stuck in the rain a little bit, but that felt okay. Motivated me to get done a little quicker. Also motivating me tonight, I want to do this in one take, which I have not always been able to do doing these. I've got some maple bourbon sirloin tips that I'm ready to grill. And so I'm leaving them right here to give me the impetus not to take 7,000 takes, because if that happens, it'll be too late for me to grill my dinner at a reasonable hour. So tonight we're going to talk about pro bono legal services. Some stats for you, some rules, and some pro bono opportunities. I thought of this today on the run. Hold on a second. That I was on. Tomorrow I have a meeting. I am the current chair of the VBA's pro bono committee, which is saying nothing because the person who makes that committee work is Mary Ashcroft. But during the run, I was thinking about the agenda we have for tomorrow, and I thought, well, what better way to get ready for the meeting than to give you some stats, rules, and opportunities on pro bono. And thank goodness I saved it. I almost lost it there by messing up the screen share, which really would have bummed me out because then I would have had to start from scratch, which is exactly what I don't want to do. So here we go. I have bad news and good news when it comes to pro bono. Here's sort of the bad news. These stats show the extent to which there is a need in Vermont's legal system. These stats are from a study that Judge Davenport did in 2012 that looked at the number of litigants who did not have a lawyer. So you see their active parentage cases, 84% of the litigants, no lawyers. Tenants, 90% of the time, unrepresented. Collections cases, the defendants, 84% of the time, no lawyer. Foreclosure cases, 74% of the time, the defendants, no lawyer. Divorce matters, family matters, 54% of the time, at least one party is unrepresented. These types of cases accounted for 72% of the civil docket. Again, that was 2012. I have no reason to think that things have gotten better. Here's some of the good news. Vermont lawyers rock when it comes to pro bono work. In 2018, the ABA did a survey on pro bono. 24 states participated, 47,000 lawyers. Vermont was one of the states that participated in the survey. The questions asked lawyers, for their experience with pro bono work. Variety of questions. Here's why I say we rock. First, 41% of Vermont's lawyers are reported having agreed to a limited representation with a client in order to help a client reduce fees. And we're going to talk about limited representations later. That was number 2. Sorry, go back. We were second only to Wisconsin. When it came to offering reduced fee service to low bono or modest means clients, again, we're going to talk about that later, we were number 1. 33.6% of Vermont lawyers offered reduced fees to low bono or modest means clients. And when it came to doing pro bono work in general, we were also number 1. 77.5% of our lawyers who responded reported having done some pro bono work, which put us at number 1. So in those 3 categories, we are the champions. We are the champions. Okay, there we go. That's my intro for tonight. So let's talk about increasing access, and pro bono is really about increasing access. I get a little pushback with people who say, well, Mike, I can't do pro bono, or I can't assist with increasing access because it violates the rules, puts me at risk of violating the rules. I did a whole seminar on this at the law school a couple years ago. It was an hour and 20 minutes. I'm summing it up in about 3 slides today. That is a load of crap. There's nothing unethical about doing pro bono work or helping to increase access. If you look through the preamble to the rules of professional conduct, you will see 4 or 5 different quotes that make it very clear that lawyers have a duty not only to ensure the quality of justice, but to ensure access to justice. And that's in the preamble to the rules of professional conduct. I took those slides out because it would just be me reading to you, and I don't want to do that or focus on that tonight. But I'll be very simple. To me, when you get right down to it, the rules of professional conduct prohibit lying, cheating, and stealing. I can actually make an argument in a different seminar. You tell me a rule of professional conduct, and I can fit it into one of those: lying, cheating, or stealing. In my view, increasing access, getting people heard, helping them be heard in court, there's nothing about that that involves lying, cheating, or stealing. So anybody who tells you that the rules prevent you from doing pro bono work, I 100% disagree. And that's my position. Very simple. Don't take my word for it. Here's a good quote from the Louisiana Supreme Court from 1976, so 44 years ago. People watching this video weren't even born then. No bar disciplinary rule can or should contemplate depriving poor people from access to the court so as effectively to assert their claim. Great quote. Okay, let's do a little pre-test. The basics. I think I have 9 questions. Drinking my tea to try to warm up from that run, and it's raining out and getting chilly. Anyway, pre-test, 9 questions. How much pro bono work do the rules encourage Vermont lawyers to provide each year? Is it A, a reasonable amount, B, 50 hours, C, 60 hours, or D, a meaningful amount? I actually used this question Friday in the 5 for Friday quiz. Check out my blog. I'm going to go through these kind of quickly because, again, if you've seen this before, you can pause or rewind. You're watching a video. Question 2, is this true or false? The rules exempt government and nonprofit attorneys from the pro bono expectation. Question 3, here's the scenario. Client retains lawyer and agrees to pay lawyer an hourly fee. The fee agreement is reduced to a writing that's signed by the client. The matter ends. By then, client has paid less than 10% of the total fee and owes lawyer for approximately 60 hours of work. Lawyer stops pursuing the fee and writes off the bill. May lawyer claim the 60 hours as pro bono? Yes or no? So basically, you don't get paid. Can you then count that as pro bono? Oops, sorry. Forgot I had choices here. Is it A, yes, because lawyer did not get paid? B, yes, if lawyer does not continue to try to collect the bill? C, yes, but cannot claim the hours if client decides voluntarily to pay? Or D, no? Guess I should have looked through the slides before I started my presentation. Question 4, which section of the rules of professional conduct is relaxed for lawyers who do pro bono work at short-term legal services programs that are sponsored by nonprofits or the courts? Is it A, the trust accounting rules, B, Rule 1.1 and the duty of competence, C, the conflict rules, or D, all of the above? Question 5, per the rules, a substantial majority of a lawyer's pro bono hours should go to who? Is it A, self-represented litigants in family court, B, persons of limited means, C, organizations designed primarily to address the needs of persons of limited means, or D, both B and C? So the rule says there's a certain number of hours you should do, and a substantial majority should go to a certain type of client. Who? Question 6. Per the rules, a lawyer may, is it A, not limit the scope of the representation? That one should be ruled out immediately because we already mentioned that we're going to talk about that. B, limit the scope of the representation but may not bill for the limited services. C, limit the scope of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. Or D, both B and C. So really it's coming down to, is it B, C, or both? You can limit the scope if you don't if you don't bill. You can limit the scope if it's reasonable under the circumstances and the client gives informed consent. Question 7, Rule 1.1 requires a lawyer to provide clients with competent representation. Thus, the rule prohibits a lawyer from taking a case pro bono in a subject matter area with which the lawyer is not familiar. Is that true? Is that false, as long as competence may be achieved by a reasonable amount of preparation? Or is it false, the rule on competence does not apply to pro bono cases? So that statement, what is it? Question 8, what is the term used to describe a lawyer's act of drafting a pleading for an otherwise self-represented litigant who will submit the pleading as his or her own? Never remember if this is 2 words or 1. I've had to look it up before. I think in the slides later I have it as 1, but there's your hint. Some people might say it's 2 words. I think it's 1. So what do we call that when a lawyer behind the scenes drafts a pleading for a client? And the bonus question, this is Cheslie Kryst. Cheslie Kryst is an attorney in private practice in North Carolina. She also does a lot of pro bono work for inmates who are seeking shorter sentences. Why did attorney Kryst garner national headlines in 2019? Is it A, she was named Miss USA? B, she married one of her pro bono clients after proving the client's innocence? C, she wrote the final episode of Game of Thrones? Or D, she finished a marathon on each of the 7 continents? So that's a lawyer who does a ton of pro bono work, became pretty famous last year. Why? Okay, let's get on to the rules. So I'm not talking about all the pro bono rules today. I'm only going to talk about rules 6.1 and 6.5. Then I'm going to talk about rule 1.1, which is the rule on competence, and in particular comment 4 to that because it applies to pro bono work. And then I'm going to talk about rule 1.2c, which is the rule on limited representations. So first, rule 6.1, here's the key sentence. Well, there's 2 of them. Every lawyer has a professional responsibility to provide legal services to those unable to pay. A lawyer should render at least 50 hours of pro bono publico legal services per year. Now, in fulfilling that responsibility, and this goes back to one of the questions, here's what the rule says. The lawyer should, 6.1a, provide a substantial majority of the 50 hours of legal services without fee or expectation of fee. I'm going to finish this sentence in a minute. But without fee or expectation of fee means this, if you look at the comment, because the services must be provided without fee or expectation of a fee, the intent of the lawyer to render free legal services is essential. Accordingly, services rendered cannot be considered pro bono if an anticipated fee is uncollected. So just because I stiff you, that doesn't mean you can then count the work you did for me as pro bono. So who do you provide the pro bono work to by the rule? The rule says a substantial majority of the 50 hours should go to persons of limited means or to certain organizations, and the rule lists them all, that are designed primarily to address the needs of persons of limited means. So what is a person of limited means? The comment to the rule says that a person of limited means is somebody who otherwise would qualify for programs funded by the Legal Services Corporation, people with incomes no more than slightly above the guidelines for people who otherwise can use those programs. And then it gives examples of other organizations, for instance, homeless shelters, battered women's centers, and food shelves. Okay, so what about low bono? We know that the pro bono means I enter into the work with no expectation that I'll receive a fee. What about low bono? Well, the rule covers that. Rule 6.1a is the rule that says a substantial majority of the hours should go to low bono. The rest of your hours can go to the low bono or modest means program. And that means, per the rule, it's services that are either at no fee or a substantially reduced fee to, again, people of limited means. A list of specific charity type groups and organizations, or by participating in activities to improve the law, the legal system, or the legal profession. So you've got the substantial majority of the 50 hours that must be pro bono, which means without anticipation of a fee. Then the rest you can do by including such a service as a substantially reduced fee to certain groups. Okay, let's look through the comments. Two are important. Again, every lawyer, regardless of prominence or professional workload, so that includes government lawyers, it includes new lawyers, it includes lawyers who've been around forever. It's all of us. This comment I threw in because I agree with it 100%. So comment, I think it's in comment 1 to rule 6.1 says, personal involvement in the problems of the disadvantaged can be one of the most rewarding experiences in the life of a lawyer. I give a presentation twice a year for the VBA that's aimed at the newer lawyers who have come to Vermont, come to be admitted in Vermont either on motion or having passed the bar exam. My seminar includes, it's Eileen Blackwood usually shows up for me. Some of you know Eileen. She used to be president of the VBA. She's currently the city attorney for Burlington. And she does her section is on the pro bono rules. And she mentioned this a couple of years ago and has mentioned it ever since, and it struck me. She talks about a pro bono case that she did when earlier in her career when she was in private practice, and the long-lasting impact it had on her, having simply made a difference in somebody else's life. She also talks about how it was a type of work that was different than her day-to-day routine. So it was personally and professionally rewarding for two different reasons: doing something different and mattering, just making a difference. So again, I agree with that comment that pro bono work can be so valuable, not to just to the person who needs your help, but to you. So look into it. Okay, what about conflicts? So they are addressed in Rule 6.5, and here's what Rule 6.5 says. The conflicts rules are relaxed when it comes to certain types of pro bono programs. They're not always relaxed. Here's when they are relaxed. So Rule 6.5, if 1, a pro bono program is sponsored by a nonprofit or the court, and 2, it's a short-term program with no expectation by the client or lawyer of continuing representation in the matter, then, so we got those two things. With me so far? Okay, good. Then rules 1.7 and 1.9, which are the rules that otherwise define conflicts with current clients and former clients, they apply only if the lawyer knows that the person at this pro bono clinic is someone with whom the lawyer has a conflict, or our Rule 1.10, which is our rule that imputes conflicts from one lawyer in a firm to another lawyer in a firm. That rule only applies if the lawyer knows that this person coming before them is adverse to a client represented by one of the other lawyers who works in the lawyer's firm. So only if you know, whoops, I got a conflict here, or, oh, oops, your adversary is represented by one of my associates or partners. Those are the only conflicts that apply and would prevent you from providing service to that person who's at the program. You don't have to do a conflict check. We want you to show up and be able to provide, willing to provide services without worrying about conflicts. So not only that, but in the comments, we've added that not only do those rules not apply right then and there, they don't apply later on. So in particular, a lawyer's participation in a short-term limited legal services program will not preclude the lawyer's firm from undertaking or continuing the representation of a client with interests adverse to the pro bono client. So basically, you get back to the office, you realize, oops, I helped out somebody who's adverse to one of our clients. You have to be screened from that case, but we don't impute it to the rest of the firm. Now remember, this exception, this relaxation of the conflict rules only applies to the extent you were at that short-term limited legal services clinic. If you want to continue to represent somebody who you helped out at the clinic, then the conflict rules apply. It says that in the comment, and there's also this advisory ethics opinion from the Boston Bar Association that says, yes, we're going to relax the conflicts rules for one-time consultation at these clinics, but if a lawyer continues on, the lawyer has to run a conflict check. Okay, competence, again, I've mentioned this in pretty much every seminar I've ever done. Competence includes having the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So I get this often. Mike, I've got no idea how to handle the types of cases in which there's a great need for pro bono work. How can I do pro bono work then without violating that rule on competence? Well, I have a couple thoughts. Very easily is my main thought. Here's what comment 2 to the rule says. A lawyer need not necessarily have specialized training or prior experience to handle legal problems of a type with which the lawyer is unfamiliar. Comment 4, competence can be achieved by reasonable preparation. Mary Ashcroft, the lawyers at the Vermont Volunteer Lawyers Project, they do a great job providing trainings, information, material on how to help people in a particular practice area, even if it's one that is not your regular practice area. Also, don't forget this, you're a lawyer. You passed the bar exam. You have skills and training necessary to be a lawyer. You know how to spot issues. You know how to do legal research and analysis. You know how to formulate strategy and make an argument. You are better than nothing, even if it's an area of the law in which you have very, very little experience. Okay, limited representation. We have a rule on that. And remember, this is another way to get paid. You can get paid full on. It won't qualify for the low bono rules, but it may help somebody otherwise access justice. Or you can limit the representation and take it at a reduced fee that you can then use for that second segment of low bono services. The one you don't provide, the one where you've provided a substantial majority of hours pro bono. Now you want to get to the rest. Here's a way to do it. You can limit the scope of a representation. This is a rule of professional conduct if the limitation is reasonable and the client gives informed consent. Don't really have much by way of to assist you with what is a limitation that's reasonable. It happens often in family court where you're going for a particular aspect of the case. Be careful in bankruptcy matters and criminal matters. It's sometimes, courts have often, not just sometimes, held that in a criminal matter, bankruptcy matter, not reasonable to limit the representation, in for a penny, in for a pound. But there might be ways in other cases where you can do an aspect of the case for the client where they're going to do the rest on their own. So it's important to remember there. Oh, and sorry, when we adopted this rule, it was in 2006, and here's the reporter's notes. We want to encourage limited representations, in part to provide a framework within which lawyers may expand access to legal services by providing limited but nonetheless valuable legal services to people who otherwise wouldn't be able to afford them or even find an attorney altogether. Another statement, another indication that I was right at the start when I said, don't let anybody tell you the rules are designed in such a way as to prohibit me from helping to increase access to the courts. Same rule, same reporter's note. The terms upon which representation is undertaken may exclude specific means that might otherwise be used to accomplish the client's objectives. Like, I can't afford every single deposition. I can't afford everything that's otherwise I would be paying you to do if I had you full on, like an unlimited representation. But again, make sure that it's reasonable to not do something that you otherwise might normally do with a client who's paying full freight. Okay, this means these limited representation, a client's informed consent. 2 bar associations have addressed what does that mean. It's DC and Pennsylvania, and they've said 2 things. If you really need to explain the division of responsibilities. In particular, here's what I'm doing, here's what you're gonna have to do. Because the client may not understand what falls on the client, even though the client has asked you to limit your representation to just a particular aspect. Now, ghostwriting is a form of limited representation. Historically, there have been 2 arguments raised against ghostwriting. I'm not going to ask for guesses because I can't stand here and like call on somebody or have anybody yell anything out. So I'm just going to get straight to the answer. Here are the arguments people have raised to say ghostwriting should not be allowed. So again, let me back up. Ghostwriting, if you don't know, I write a pleading for somebody. They sign it as their own without disclosing to the court that they received help from a lawyer. The 2 arguments against allowing ghostwriting historically have been: one, courts generally will liberally construe pleadings filed by a self-represented litigant, and if that's not fair, if actually the litigant is getting legal help. And two, the failure to disclose legal assistance is misrepresentation by omission. In 2007, the ABA issued formal opinion 446, where they rejected each argument. Here's what they said about the unfair advantage. If the undisclosed lawyer has provided effective assistance, is doing his or her job, the fact that a lawyer was involved will be evident to the tribunal, the court, and there will be no reason to apply liberal construction. Also, if the assistant has been ineffective, like it's a bad motion or brief that you wrote, the pro se litigant will not have received any sort of unfair advantage. So then the ABA concludes, because there's no reasonable concern that a litigant appearing pro se will receive an unfair benefit, the nature or extent of the behind the scenes legal assistance is immaterial and need not be disclosed. Which gets to the second argument. Is it misrepresentation by omission for the lawyer to allow someone else to file something as their own when in fact a lawyer has done the work? And the ABA opinion says this: it's only a misrepresentation if the litigant is asked by the court and lies, or B, a local court rule requires the disclosure of legal assistance and none is made. So remember this, there are some courts, we're going to talk about one in a moment, that require a litigant to disclose whether the litigant received legal assistance. For instance, Local Rule 32.2 for the Second Circuit, the circuit we're in, a pro se party who submits a paper that an attorney has drafted in whole or substantial part must state at the beginning of the paper, this document was drafted in whole or substantial part by an attorney. Unless the court orders otherwise, the attorney's identity need not be disclosed. So know the rules. So if you do something for a client that's ghostwriting, my position is it's okay. Check to see what the local rule is to make sure that the court doesn't require the disclosure of legal assistance. Okay, some opportunities for pro bono work in Vermont. Mary Ashcroft, again, the VBA's legal access coordinator. She's awesome. She's got a ton of material on the Bar Association's website. There's the pro bono work, the low bono work, and then the VBA's modest means program, which is it's a reduced fee panel that's designed to make legal services available to moderate income people who don't otherwise qualify for instance legal aid or legal services corporation, but don't make enough money to pay full attorney's fees. Great program. You can make some money off it. Remember, that's a program though in which the conflicts rules will apply. Then there's Legal Services of Vermont, used to be called Law Line, changed their name last year. Angel Court, Sam Abel Palmer over there. The Vermont Volunteers Lawyer Project, a great program. So those are two super resources when if you're looking for different types of pro bono, low bono, or modest means work to do. Here we go, the answers to the pretest. 50 hours is what we encourage per year. That is false. The rules do not exempt government and nonprofit attorneys from the expectation. So you hire me, I don't pay you. Can you claim that as pro bono? No, because when you agreed to represent me, you expected me to pay you. It only counts as pro bono if there's no anticipation of a fee. The conflicts rules are relaxed when you appear at a pro bono short-term legal service program sponsored by a nonprofit or the court. A substantial majority of your hours can go to either persons of limited means or organizations designed to address the needs of those persons. You may limit the scope if the limitation is reasonable and the client gives informed consent. Rule 1.1 applies, but it doesn't prevent you from taking the case as long as competence may be achieved by a reasonable preparation. I can tell you right now, I have not once in 22 years, and over that time, I think I've reviewed, I don't know, 3,500 disciplinary complaints. Not once has somebody who showed up at a pro bono clinic then complained about the lawyer who helped them at the clinic. Not once. Question 8, that's ghostwriting, drafting a pleading. I put it as one word. Never sure if it's one or two. And question 9, Attorney Kryst was named Miss USA last year. I want to finish with my Starfish story. Some of you have heard me tell it before. So the Starfish story is the story of a little girl who late one night, about this time of night, is out on the beach. And the beach is covered with starfish that have just been washed ashore. And they're going to die if they don't get back in the water. And there's thousands of them. It's getting late. There's a storm coming. Some old grumpy guy comes walking down the beach and says, "What are you doing?" And she says, "I'm trying to help the starfish. I want to get them back into the water." He says, "It's late. There's thousands of them. You're never going to make a difference." She picks up one starfish, puts it back in the water, and says, "I made a difference to that one." That's what you can do with the one case that you take pro bono. You can make a difference to that person. You're not going to change the world. We're not asking you to change the world, but make a difference for one person. Anyway, thanks for listening. I hope you have a great night. I made it through, and now I'm going to go cook my my maple barbecue sirloin tips. Have a great day. Talk to you next time.